Joe Bowser here for another edition of Readymode's TCPA Compliance Guides. Today we're going to cover the top 4 myths of TCPA compliance. Again, I'm Joe Bowser, head of Roth Jackson's TCPA Compliance and Defense Group. I've been practicing TCPA and telecommunications law for over 20 years now. So today, our top 4 myths. Number 1, you cannot call numbers on the National Do Not Call Registry. That's not true. It's a myth. You can under a variety of circumstances, and you need to know what they are. First, the Do Not Call Registry only applies to telephone solicitations. So that, in plain language, is a sales call. You are calling the called party to try to encourage them to buy, rent, or invest in property, goods, or services. So if you are calling them for some other purpose, an appointment reminder, a delivery reminder, a market research call to buy something from them, call to offer them a job, as long as you are not calling them for the purpose of causing them to pay you or the person that you're working for or your client, generally speaking, it's not a telephone solicitation. Not all plaintiffs or regulators understand these nuances or necessarily honor them, but that is the law, and there's a number of cases around the country holding that telephone solicitation means what it says in the law and in the regulations. So the first things first, for the DNC regulations to matter, you need to be making sales calls. So let's assume that you are. If you are making sales calls, there are a number of reasons why you still can call people on the National Do Not Call Registry. For example, you can have a personal relationship with that person. That's not typical in TCPA defense cases, but that is one of the explicit exceptions. 2 of the more common exceptions are what's called an EBR, or prior express invitation or permission. We'll go through each of those in turn. So, EBR, that's an established business relationship. You can have that in one of 2 ways. You can have an inquiry EBR, which is when the consumer reaches out to you and makes an inquiry. I go to my local car dealership and I ask them to show me a car. If I give them my number in the context of that inquiry, they have 90 days to close the sale unless and until I tell them not to call me again with sales calls if I tell them that before the 90 days expires. If I make a transaction with a seller, the EBR in that case, in the transaction EBR, lasts for 18 months from the life of the transaction unless I terminate it sooner by making an internal do not call request to that seller. So that's an EBR. Again, there's 2 kinds. The 90-day inquiry EBR or the life of the transaction plus 18 months transaction EBR. That's the established business relationship. Those can be in writing, don't need to be. Certainly it's your burden to prove as the caller or seller. So you want to document those well so that you can prove your defense with competent evidence. And it certainly makes it go faster when you're dealing with an intransigent plaintiff or a plaintiff's lawyer who is suspicious of your practices. So certainly best practice is to document those EBRs, but it doesn't need to be. Another basis to be able to call someone whose number is on the National Do Not Call Registry for a sales call purpose is if you have their prior express invitation or permission. That is expected to be in writing, and it doesn't require the same formality, that prior express written consent that you've probably heard about in other contexts. It doesn't require the formalities of prior express written consent, which only applies to so-called 227B type calls, which are either pre-recorded, artificial voice, or if you can still find one these days, an auto dialer call. So that's what 227B regulates. 227C is the subsection of the TCPA that deals with calls to numbers on the National Do Not Call Registry. So those are the 2 key ways that you can still make sales calls to numbers that are on the National DNC. Make sure that the relationship that matters is with the seller who you're calling on behalf of. So it is not okay to just buy a list of numbers that happen to be on the National Do Not Call Registry, even if the seller of that list has said, oh, these people are interested in whatever your vertical is, insurance, solar, whatever. The relationship needs to be with the calling party or whomever you're calling on behalf of, the seller. So make sure that there's a nexus there between the called party who's on the National Do Not Call Registry and the person who's actually calling them, the seller, in a sales call. Okay, that dispels the myth that you cannot call people on the National Do Not Call Registry ever. That's just not true, for at least two main reasons. One, it has nothing to do with non-sales calls. And two, there are a number of important exceptions to the restrictions because by definition, telephone solicitations do not include calls that are made with an EBR or with the called party's prior express invitation or permission. A second related myth is that B2B or business to business calls are not regulated by the TCPA at all. That's not true. And we're going to break this down by the TCPA's two core sections. First is 227B, which I mentioned a moment ago. The 227B regulations apply to the technology you use to make calls and has less to do with the subject of the calls. It can matter in terms of the level of consent that you need to make those sorts of regulated technology calls, but 227B applies to all calls that you make with an auto dialer called an automatic telephone dialing system under the TCPA, or pre-recorded or artificial voice, which you should assume includes AI calls. If you're making that type of regulated technology call to specific types of phone numbers, you need varying levels of consent depending on whether it's an informational call or a telemarketing call. So if you are making a pre-recorded voice call to a business number that happens to be a mobile number or a VoIP number that incurs a charge for the call, for example, those calls are subject to 227B and you need to get the applicable level of consent for those calls. So think about B2B calls first under the lens of 227B, and if you're using regulated technology and you are calling certain kinds of phone numbers, which includes mobile numbers, paging services, if those are still a thing, and VoIP numbers that incur a charge for the call. So there are scrubbing services for wireless that are competent. It is more difficult to know whether a VoIP number incurs a charge for a call. So if you're going to be using regulated technology, you want to get with competent counsel and possibly a technology vendor who can get you the scrubbing services that you need if you don't have consent to call those numbers. But the most bulletproof legal means to make those sorts of regulated technology calls is to get the right level of consent in the first place. On the DNC side, the DNC rules, by their own terms, only apply to residential lines. The challenge comes in with mobile phones. So the legal landscape is shifting after major Supreme Court changes in the past year about the manner in which or the extent to which courts have to defer to FCC decisions. But some courts, like the Ninth Circuit Court of Appeals that applies to California, Oregon, Washington State, Arizona, some other West Coast jurisdictions, they have also independently held that cell phones are presumptively residential and that it's the caller's burden to rebut that presumption. So certain major jurisdictions have already ruled that cell phones are presumptively residential. That's not the case everywhere in the country, but it's something to keep in mind. But the federal law, on its face, only applies the DNC rules to calls to residential lines. And the FCC has long acknowledged that Congress made that choice, and it respects that choice. The question is how you identify and prove whether a given cell phone number is a business number or a residential number, and that is a commonly litigated fight. It's certainly something that should prevent a class certification on a DNC case from ever being certified if it's your practice to generally call business numbers, as long as you're using a technique that is reasonably calculated to make sure that you are only calling business numbers. But be prepared to prove up that you have a bona fide mechanism for isolating business lines, because it does get challenging when a a person uses a cell phone for both residential and business purposes. Like a common example would be a realtor who uses their personal cell phone for lots of business purposes, and you can find it online on Zillow, Remax, or whatever brokerage house they work for. So it is technically true that the DNC regulations don't apply to business numbers, but typically you should expect to have to bear the burden of establishing that a given number you're calling is in fact a business number. And I have a fair number of TCPA cases that I defend where it seems pretty obvious that it is a business number because you can find it online in a variety of contexts being used in a business context, but the plaintiff will still insist that privately they use the phone more for personal purposes and residential purposes. And defending a case where there's a dual use of the number can be expensive to defend because you still need to get into discovery to establish those facts that would only be held by the called party. So, as a legal matter, yes, calling business lines is not subject to the do not call rules, but proving it isn't necessarily free. So be thoughtful about where you're curating your lists and how you're getting your business lines before you start calling business lines that are also on the National Do Not Call Registry, because it will involve potentially some defense costs. So that's the second list. The TCPA does apply to B2B calls in certain respects. Not all of them, but in certain respects. And so you definitely want to work with competent TCPA counsel to work through the nuances of your campaigns. All right, myth number 3. Only the caller is subject to the TCPA. That's not true. For many, many years, the FCC has expanded TCPA liability to those who are subject to what's called the vicarious liability doctrine. Vicarious liability is, in a common layperson example, when UPS Corp sends the driver in the brown truck in the brown uniform to deliver a package to your house. If they run over the dog, you are probably within your rights to sue UPS because they were controlling what that driver was doing, the manner in which he performed his work, and they are responsible for his negligent or intentional acts. So that's the idea that vicarious liability is meant to cover. At federal common law, which is the jurisprudence that applies to the agency doctrines under the TCPA, you can establish vicarious liability a number of ways. You can establish that the seller has cloaked the caller in actual authority. If the seller has hired the caller and, for example, given them a list of people to call, given them a script of things they should say, suggested other ways to control their conduct, that's giving them actual authority. A caller can create apparent authority by having things that the seller says in public, a called party, a reasonable basis for believing that the caller has cloaked them with responsibility and agency to act on behalf of the seller. And finally, if the seller commits what's called ratification, where they ratify potentially TCPA violating conduct, if the called party can prove that a seller knows or has reason to know over a period of time that a given caller is violating the TCPA and nevertheless reaping the rewards of that caller's campaigns, it can create an agency relationship that wouldn't otherwise exist but for that knowledge of the putative the putative seller about what that caller is actually doing. So there's a number of ways to prove vicarious liability on behalf of a seller who isn't touching the phone or the text message, but they can be held vicariously liable for TCPA violations of the party who's in direct control of the communications. So if you are a seller hiring marketing vendors or contractors, you want to be very careful about how you structure those relationships, because those will determine the ability of the called party and their lawyers to make viable vicarious liability allegations. Obviously, in complaints, the plaintiff's counsel will typically plead things that usually have no basis in reality, but they're trying to get themselves into discovery to prove a vicarious liability case against a seller who often has more financial wherewithal to satisfy potential TCPA liability on a class basis. So it is not the case that only the caller is subject to the TCPA, and if you are engaging third parties to make calls or texts on your behalf, it is certainly something that you want to be doing thoughtfully. And how you navigate those relationships is important, because the more control you exercise, the more favorable facts you may give the called party and their lawyers on a vicarious liability argument. So that is something that's sensitive, nuanced, and something that you definitely want to get with your TCPA counsel on to make sure that those are structured in a way that works for your business and your risk profile. And finally, the fourth myth that we're going to cover today is the idea that the TCPA just does not apply to manually dialed calls, that you can still pick up a phone and call whoever you want. That's not true. The 227B regulations do not apply to manually dialed calls because, again, as I mentioned earlier in this video, they only apply to calls that are made with an automatic telephone dialing system, pre-recorded or artificial voice. So yes, if you were picking up a phone and dialing 10 digits or using some other technology that replicates that experience, 227B doesn't apply to you, but the 227C section and the FCC's regulations under that law do apply if you are making sales calls to numbers on the National Do Not Call Registry. So we go back to the subject that we were talking about first, which is 227C regulations that apply to telephone solicitations. So if you're making manually dialed calls that are sales calls to numbers on the National Do Not Call Registry, you need to be very thoughtful about what the legal basis for those calls is. And again, you need an EBR or consent, or if you don't have either of those, you should be engaging a competent DNC scrubbing service to scrub your lists to make sure that you do not call numbers on the National Do Not Call Registry. You or your BPO or your caller needs to have a SAN, a subscription account number, with the FTC, the Federal Trade Commission, because that's the agency that maintains the National Do Not Call Registry. And you need to scrub your calling lists at least every 30 days, because obviously new numbers get added to the National Do Not Call Registry every day. You need to have written policies and training so that you train your personnel about your internal practices and procedures, and that you maintain your own internal do not call list. Because when the FCC first enacted its DNC regulations in 1992, the two regulations that it first implemented were establishing an internal do not call list and time of day restrictions. So those are the two that have been around the longest. And it wasn't until 2003 that Congress enacted the 2003 Do Not Call Implementation Act that required the FCC to marry up its internal and national Do Not Call Registry regulations with those of the FTC. Those are the National Do Not Call Registry regulations that have been around for the last 22 years that apply to certainly calls. And some courts have started to say that they also apply to text messages after the FCC ruled that in 2023, and those regulations went into effect in 2024. And there is a significant dispute in the courts over the extent to which those DNC regulations to text messages are lawful, because Congress never used the expression text messages in the TCPA, even though it did expand the Truth in Caller ID rules to text messages in 2018, but never changed the TCPA like it did the Truth in Caller ID Act. The obvious assumption being that Congress knows how to regulate text messages and did not for the TCPA. So there you have it. That's today's TCPA recap. We debunked 4 very common myths that plague many TCPA defendants, that had they engaged competent TCPA counsel, They would not be talking to them about a lawsuit, but instead would be having some relatively brief compliance calls. So do keep that in mind if you're picking up the phone or sending text messages to folks on the National Do Not Call Registry, or using any of the types of regulated technology that we covered in today's video. So I hope you find that helpful. Thanks Readymode for giving us the chance to talk about these important TCPA lessons, and I look forward to sharing more insights on the next video. Thanks.